on to another story that we are tracking this morning, and this comes by way of a new Income Tax Appellate Tribunal, and that ruling now gives clarity on only the number of days NRIs spend in India to be relevant in assessing the tax status of NRIs. Will they or won't they be tax residents? Now, joining us to discuss this very important story this morning is Mr. Karanjot Singh, his partner Lakshmikumaran and Sridharan. Mr. Karanjot Singh, thank you so much. Good morning and thanks for being here with us. Help us understand what is this new ITAT ruling and what does it mean for NRIs?
Hi, good morning, Kartik, and good morning to all the viewers. So, Kartik, before we discuss the actual judgment, I just wanted to take some time to reflect on the legal provisions that have been discussed by the Mumbai bench of ITAT in their order determining the residency of an individual who had left India to exercise employment in USA. Now, in India, the taxation of an individual is dependent on their residency in India. This is important because a person who is a non-resident is assessed only in respect of their Indian sourced income as compared to a resident who is taxed on their global income. So therefore, classification into a resident or non-resident essentially can significantly alter your tax liabilities in India and can also bring in your foreign sourced incomes to tax in India if you're determined to be a resident. Now, typically, the residential status is determined on the basis of the stay of the individual in India. So if an individual is residing in India in 182 days in a given financial year, the individual is assessed as a tax resident of India, or in the alternate, if an individual is in India for 365 days in 4 years prior to the tax year and for 60 days in a tax year, they are still assessed as a tax resident of India. So in either of the conditions, the individual could be assessed as an Indian resident. Now, in a case of an individual
if I can just cut you in here, Karanjot, so help us understand. You're saying 182 days in a year is not sufficient. Even if an Indian spends 60 days in India in a tax year, then his overseas income is subject to taxation in India. Is that what you're saying?
So if the individual is in India for 60 days in a given financial year and 365 days in 4 years prior to that, even then the individual could be assessed as a tax resident of India, despite the fact that he's not spent 182 days in a given financial year. Now,
what is this 182-day new ruling which has come in? Now, what does this 182-day mean if you're saying that 60 days also makes you liable to pay taxes in India?
Right. So an individual who is a citizen of India, who is actually leaving India for the purpose of exercising employment outside India, there the condition of 60 and 365 days, etc., that practically does not apply. So the moot point in this judgment is as to whether the individual who had left India but had spent a short duration in search of employment, whether the period that was spent in search of the employment could be counted for the purpose of determining the residency or not. So the peculiar facts that were before the ITAT were, so here one Mr. Gulati, he was in India for a period of about 156 days during the financial year 15-16. And he was in USA for 210 days in the given financial year. Now, out of the 210 days, for 28 days, he was actually searching for employment in USA. And for the remaining period of 182 days, he was actually exercising employment there and he was actually receiving salary remunerations there. Now, it was the tax officer's contention that the law provides exception only for the days when you're actually exercising employment outside India. So therefore, according to the tax officer, while the 182 days where the individual was actually exercising employment could be counted as days outside India, the 28 days where no such employment was exercised could not be excluded for the purpose of determination of Indian residency. In other words, the tax officer added the 28 days to the 156 days where the individual was actually present in India and determined the period of presence in India to be 184 days.
All right.
Now, because the individual had gone to exercise employment outside India, that the officer was not disputing. As per officer also, the period of determination of residency was only 182 days, but by adding 28 days on top of it, the individual was becoming a tax resident of India.
All right. So, Karanjot, if I can just draw in some more clarity here for the sake of our viewers, especially those who are NRIs and watching us from outside of India. If there is somebody of Indian origin, a citizen of India who is working outside of India and spends less than 182 days on Indian soil, then there is no need for him or her to pay taxes in India. Am I right?
Yes, Kartik. I would just want to add to that. So here we were dealing with assessment year 16-17. Pursuant to that, in 2021, the law has slightly been amended.
All right.
So in cases of NRIs who are visiting India, coming back to India, there in certain cases, they could be treated as resident but not ordinarily resident if they spend more than 120 days in India.
Right.
Provided they have Indian sourced incomes exceeding 15 lakhs. So that's an amendment that was made in 21. But by and large, what you said still holds.
All right. And just one more point of clarity for those who are spending, let's say, more than 182 days in India, they are liable to pay taxes on India. What would be their tax slab on the income that they are earning overseas? Is that going to be the Indian tax slabs, the Indian tax law which will kick in? Or are they going to pay taxes which are in sync with the tax laws of the country where they are earning that overseas income? Or is it going to be a case of double taxation? They pay taxes in the home country and back here in India as well.
Okay. So, Kartik, in cases of individuals who are actually dual residents, that is to say, they become residents of one of the countries by applying the test of that particular country as also residents of India, the treaty protection comes in, and there is a tiebreaker test in the treaties to determine where the individual is resident. Assumingly, even if as per the treaty, the individual is a resident of India, the Indian slab rates apply to the global income. In other words, the entire total income, be it Indian sourced income or the foreign sourced incomes, they are subject to tax in India as per Indian slab rates.
All right. Got it. Well, let's leave it at that. Karanjot Singh, partner, Lakshmikumaran and Sridharan, thank you so much for joining us this morning and helping us try and understand this fairly complex tax story here. But we will keep coming back to you as and when there is such a story.